In public session, and we're resuming an amendment number 98 in the name of the Minister. Again, can I remind everybody to please turn off mobile phones or put them such a way that they won't interfere with the actual sound system. The Amendment 98 in the name of the Minister. Acceptance of this amendment involves the deletion of section 45 of the bill. If 98 is agreed, 99 and 100 cannot be moved. 99 and 100 are alternatives to 98. 99, 102, 108, 110 and 112 are related. 102 is an alternative to 101. 101, 103, 104, 105, 107 and 109 are related. 106 is an alternative to 105. 98 to 110 inclusive, and 112 will be discussed together. Minister, to move.
Yes, Chairman, I so move. We now come to the provisions dealing with professional misconduct by legal practitioners. Government Amendment number 98 contains several amendments. We're just dealing with Government number 98. Firstly, there are several amendments have been made to section 45, which sets out the types of acts or omission of a legal practitioner that may be considered as misconduct. Most notably, misconduct now comprehends a bill of costs which is grossly excessive. In determining whether the bill of costs is grossly excessive, the authority, the divisional committee, disciplinary tribunal, or the High Court may have regard to the following: the amount by which or the extent to which the amount claimed was found to be excessive, whether in the particular circumstances of the legal service performed the amount of the bill of costs appears to be unconscionable, and whether or not a legal cost adjudicator has found the costs charged to be grossly excessive. Other amendments to this section provide that the failure of a managing legal practitioner of a multidisciplinary practice to comply with his or her obligations under the Act may constitute misconduct. We have also included a subsection that in the case of solicitors, an act or omission that constitutes a material breach of the solicitor's accounts regulations may now amount to misconduct. In addition, if an act or omission consists of an offence under the bill, it may constitute misconduct. Finally, we've also inserted a new subsection M, and I quote, "The Act consists of a contravention of section 118 118 subsection 1 unquote, that is, where a legal practitioner who has accepted instructions to appear in court on behalf of a client who is in custody withdraws from the client's case without obtaining permission from the court before which the client is next scheduled to appear. That may now constitute misconduct." I'd like to turn now to opposition amendments 99, 102, 108, 110 and 112. If the Chair would permit me to group these together with this listed group. All of these amendments, from my reading of them, are taken from the Bar Council's submission of March 2012. I'm opposing these amendments, which have previously been considered, as they were included in the Bar Council's submissions and were so considered. In essence, the amendments seek to provide for supervised self-regulation and run counter to current government policy as expressed in the bill, and its provisions for independent regulation of the legal profession, including a regime to deal with professional conduct and discipline. Essentially, they hark back to the era when it was proposed that a legal services ombudsman was all that was required, and that there would be oversight, but that the professional bodies would continue to self-regulate rather than we should have independent regulation. Independence is important. Turning now to opposition amendment 100, which relates to legal executives. The bill does not make any provision in relation to the role or status of legal executives, nor is any such provision envisaged. While recognising that there may be additional benefits and efficiencies to be found for consumers and for the legal services sector in a more developed role for legal executives, such matters will need to be considered separately on their own merits, while others may come to be considered in due course by the new Legal Services Regulatory Authority. The bill deals with solicitors and barristers as legal practitioners and will not be extended beyond that in its scope. In relation to Government Amendment number 101, Section 46 provides that misconduct complaints on or after the coming into operation of this part will be made to the authority. Subsection 3 provides that the period beginning on the making of a complaint to the authority and ending 2 months after the complaint is determined shall be disregarded in reckoning any period of time for the purpose of any limitation period in relation to the making of an application for adjudication of a bill of costs under Part 9. In relation to Government Amendment 103, Section 47 provides that the authority may make regulations regarding the making of complaints to the authority under this Act and the procedures to be followed by the authority and the Complaints Committee in investigating complaints. I now want to refer to Opposition Amendment number 104, which was also contained in the Bar Council's March 2012 submission. I am opposing this amendment. In essence, the Government's amendments set out detailed provisions regarding how complaints regarding inadequate services, excessive fees and misconduct will be processed and investigated by the new Legal Service Regulatory Authority, the Complaints Committee and the Legal Practitioners Disciplinary Tribunal. Now, I want to turn to Government Amendment 105. Section 48 provides that the authority may make regulations prescribing the fee, if any, payable in respect of making a complaint. I would like to assure deputies that it is not intended that any such fees should be a disincentive to the public in their making of complaints. I'm afraid I must oppose Opposition Amendment 106, tabled by Deputy McGrath, on the grounds that it represents a watering down of the authority's power to expect and enforce cooperation and compliance by legal practitioners with the authority. Essentially shifts that regulatory oversight power to the High Court in a way that I cannot accept. Government Amendments 107, this provides for Section 47, which sets out the criteria for the admissibility of complaints for misconduct. It's been very slightly amended from the admissibility of complaints section, which was in the published bill. Like the admissibility of complaints regarding inadequate services, a complaint under this part will not be considered by the authority if, in the opinion of the authority, it is deemed to be frivolous or vexatious, or if it is without substance or foundation, or does not satisfy the other criteria prescribed in the section. When the authority determines that it will not consider a complaint, it will have to notify the complainant in writing, setting out the reasons, and also notify the legal practitioner. On determining under this section that it will consider a complaint, the authority shall proceed to investigate the complaint subject to the resolution and complaints provisions that we discussed earlier. I now want to refer to Government Amendment 109. And alongside the admissibility procedures, we have created a new preliminary review of complaints section, which is in Section 50, which will enable the authority to conduct a preliminary review of the complaint to determine whether or not the complaint is admissible and whether the complaint is an appropriate complaint to be dealt with by the authority offering assistance in resolving the matter. That's Section 51, whether the complaint should be sent to the Complaints Committee. I think, Chairman, that in summary that addresses all of the amendments that I've proposed and responds to the amendments that are tabled in the names of opposition members.
Thank you, Minister. Anybody else want to come in any of those amendments? Deputy McGrath.
And just in relation to amendments 104, is it? Yeah, 104 and 106. I mean, I do take the point that it's important that we be very careful on the issue of supervised self-regulation, and I would personally be very supportive of keeping it independent. But I also think it's important that when these amendments are put down, that the views of people who work and are members of the Bar Council, that their views are put on the record and an attempt is put into the legislation, so the Minister and the officials and the people dealing with this legislation can look at these ideas and take some of the ideas out of the amendments, which I think are very, very important. But I think that it's a very democratic and open system where I don't necessarily agree with every single amendment, but they are put forward in an open forum like the Oireachtas Committee on Justice. Thank you.
Anybody else? Okay. All right, then we'll start going through them. On amendment number 98, the question is that the new section be there inserted. Is that agreed? Amendment number 99 cannot be moved accordingly, neither can amendment number 100. Amendment number, the question is that the section 45 stand part of the bill, and the Minister, I think, is going to say no to that.
Neil?
No. Not agreed?
Yes, Neil.
Not agreed. That's lost. Section 46, Amendment 101, in the name of the Minister, already discussed with 98. The question is that the new section be there inserted. Is that agreed?
Agreed.
Agreed. 102 cannot be moved. And the question about the section, that section 46 stand part of the bill, and that's in the negative as well, I think.
That's another negative.
Is that agreed?
Chairman, just on a technical matter, but once we accept the new section, does that not produce the automatic deletion of the other section?
No, you're putting in a new part.
Sure,
go through
and
each
we have to
section
delete the ones we're taking out. Okay.
Yeah.
Put the new section before the existing section, so you have to then discuss it.
Yeah, okay. That section 46 stand part of the bill. Is that agreed?
That's a Neil.
Not agreed. Okay, that falls. Okay. Section 47, in the name of the Minister, amendment number 103, already discussed in 98.
Agreed.
Questions that new secretary there and says that agreed?
Agreed.
Agreed. Amendment number 104 cannot be moved. Now on the section, that section 47 stand part of the bill. Is that agreed?
Neil.
No. Not agreed. Then it falls. Section 48, Amendment 105, in the name of the Minister, already discussed with 98. Questions that the new section there inserted. Is that agreed?
Agreed.
Agreed. Amendment 106 cannot now be moved. And the question now is that Section 48 stand part of the bill. Is that agreed?
Neil.
No. That is the section falls. Section 49, Amendment 107, in the name of the Minister, already discussed 98. Questions that the new section there inserted. Is that agreed?
Agreed.
Agreed. 108 cannot now be moved. And the question is that Section 49 stand part of the bill.
Neil.
And that's not agreed, so that falls. Section 50, Amendment 109, in the name of the Minister, already discussed with 98. Question is that the new section there inserted. Is that agreed?
Agreed.
Agreed. 110 cannot now be moved. Section 50 stand part of the bill.
Neil.
And that's in the negative, and that falls. Section 51, in the name of the Minister. Acceptance of this amendment involves the deletion of Section 51 of the bill. If 111 is agreed, 1112 cannot be moved. 111, 113, 114 and 116 are related and will be discussed together. Minister to move. We're on 111.
Yes, sorry. Yes, I so move, Chairman. This Government Amendment number 111. Under our new Section 51, the authority may offer assistance in resolving the matter in dispute where it appears that the conduct could constitute misconduct, but it is felt by the staff member carrying out the preliminary review that the subject matter of the complaint is capable of being substantially resolved by the legal practitioner concerned in a prompt manner in accordance with the authority's guidelines. It is important to note that the Act remission the subject of the complaint cannot relate to fraud or dishonesty, which is to be dealt with separately under the conduct regime. The agreement by the complainant and the legal practitioner to make efforts to resolve the matter does not prevent the authority continuing with its consideration or investigation of the complaint. I'd refer members to Section 51, subsection 2 in that context. However, if the Complaints Committee, the Disciplinary Tribunal or the High Court is satisfied that an act or omission of a complaint has been resolved by the legal practitioner or that proper effort was made by him or her to resolve the matter, then in determining the appropriate sanction, they have to make due regard to the efforts made to resolve the matter. I now turn to Government Amendment number 113. Section 52 provides that no answer or statement by the complainant or legal practitioner in the course of attempting to resolve a complaint under Section 51 may be used in any disciplinary, civil or criminal proceedings or communicated to any other person. Government Amendment number 114, that relates to Section 53, which provides that the agreement by the legal practitioner to participate in the resolution of the matter under Section 51 shall not be treated as an admission of liability. This is so as to try and encourage, obviously, a resolution of a matter if it's possible, and it's then, of course, left to the authority to determine how matters should be dealt with thereafter if the resolution is effected. Government Amendment number 116, section 55 provides the authority shall prepare and publish guidelines in relation to the resolution of complaints by mediation or informal means. The guidelines may set out the process whereby determination can be made in respect of whether a complaint can be resolved by mediation or informal means. So that allows the authority to give some indication of the approach to be taken by way of guidelines in respect of mediating complaints or them being informally resolved. And I think, Chairman, that concludes an overview of what the various amendments comprise.
Okay. Deputy McGrath, we're also doing 112. Do you want to comment on that, or do you wish to?
No, just I move it.
Well, you can just, we'll move it until we get to it.
Right.
But yeah, already discussed 98. Oh, sorry, I discussed 98 anyway, sorry. Okay, then, so if nobody's anything else to say, we'll put the question that Amendment 111 in the name of the Minister, that the new section be there inserted. Is that agreed? Agreed. Amendment 112 cannot now be moved. And the question is that Section 51 stand part of the bill. And that's in the negative as well. That's needed, that falls. Section 52, Amendment 113 in the name of the Minister, is a new section already discussed with 111. The Minister to move.
I move.
That a new section be there inserted. Is that agreed? Agreed. Amendment number 14 in the name of the Minister, is a new section already discussed with 111. Minister to move.
I move.
That the question is that a new section be there inserted. Is that agreed?
Agreed.
Agreed. Amendment number 115 in the name of the Minister. This is a new section again coming in here. 115, 117, 118 and 119 are related and will be discussed together. Minister to move and discuss. To move 115.
Yes, we have to come back to that. Yeah, I so move, Chairman. Just give me a moment to get there. Yes, we're now dealing with a series of further amendments. To take the first one, which is Government Amendment 115, Section 54, which deals with complaints relating to fraud and dishonesty, is of course a very important section and provides that where the complaint relates to a solicitor and the authority considers that the complaint or part of the complaint would constitute fraud or dishonesty on the part of the solicitor, if substantiated, the authority may A. proceed to carry out an investigation under the new Part 5 investigations, B. refer the matter to the Complaints Committee, or C. require the Law Society to carry out an investigation under the Solicitors Acts 1954 to 2013. This enables such fraud and dishonesty complaints to be dealt with expeditiously in their own right and in the public interest. Government Amendment number 117, which deals with the Complaints Committee. The cluster of amendments relating to a new Chapter 2 deals with the consideration of complaints by the Complaints Committee. As such, it develops many of the sections dealing with the complaints procedures currently in the bill as published. Section 56 provides that the authority will establish a committee to be known as the Complaints Committee for the purpose of considering and investigating complaints referred to by the authority. Key change from the published bill is that the requirement for the approval of the Minister to the appointment of the members of the committee has been removed. Another key change has been the increase in the membership of the committee from 16 to 27 members so as to prevent any backlog of complaints developing, and so there's also not an undue pressure or amount of work imposed on a small number of members. The Law Society will now nominate 8 members, previously 3. The Bar Council will nominate 4 members, previously 3. The greater increase in the Law Society nominations reflects the reality that there are significantly more solicitors than barristers in the state, a factor of 5 to 1. It's also envisaged that the Complaints Committee may act in divisions of 5 members as well as divisions of 3 members. Each divisional committee will have a majority of lay members, one of whom will be the chairman or chairperson. Where a complaint relates to a solicitor, the divisional committee is comprised of 3 members. One of the members of the divisional committee will be a solicitor. Where the complaint relates to a solicitor and the divisional committee is comprised of 5 members, 2 of the members of the divisional committee will be a solicitor. Where the complaint relates to a barrister, the same ratio will apply regarding the barrister composition of the divisional committees. We've made slight amendments to section 56(4) dealing with the appointment of the lay members of the Complaints Committee. The lay members will be persons who are independent of the legal practitioner's professional bodies and have expertise in or knowledge of 1. The provision of legal services, 2. The maintenance of standards in a profession, including those regulated by a statutory body, 3. The investigation and consideration of complaints relating to services, 4. The interests of consumers of legal services. Government Amendment number 118. We've developed section 57 dealing with the investigation of complaints. When referring a complaint to a divisional committee, the authority will now prepare a summary of the complaint which will be furnished to the divisional committee. The divisional committee will also furnish the legal practitioner with a copy of the complaint and request his or her response unless the legal practitioner has already been furnished a copy of the complaint. Where the divisional committee receives an explanation from the legal practitioner concerned indicating that the act or omission did not constitute misconduct, it must furnish a copy of the explanation to the complainant, inviting the complainant to furnish his or her observations on the explanation of the legal practitioner. Where the response of the legal practitioner does not satisfy the divisional committee that the act or omission did not constitute misconduct, where the legal practitioner does not furnish a response within the period specified in the notice, the divisional committee will take such steps as it considers appropriate to investigate the complaint. For the purpose of investigating a complaint, and this is dealt with in section 57, subsection 6, the divisional committee, A, will have regard to information furnished to it by the authority, B, may, by notice in writing to the complainant, do one or more of the following: require the complainant to verify by affidavit or otherwise anything contained in the complaint, request the complainant to supply to the committee such information or documents relating to the complaint as the committee may require. 3. Require the legal practitioner, the subject of the complaint, to supply the committee with such information or documents the committee may require. The divisional committee may now require the complainant and the legal practitioner to appear before the committee for the purposes of investigating the complaint. The complainant and the legal practitioner may be represented by a person of their choice before the divisional committee. The cost of such representation will be borne by the person who requested it. Another new feature contained in section 57, subsection 11, is that if a complaint is withdrawn when it is being investigated by the divisional committee, the committee may decide that no further action be taken, or it may proceed as if the complaint had not been withdrawn. Like the published bill, in section 51(4) of the published bill, the amendments of section 57, subsection 12, provide that where the divisional committee determines that the act or omission does not constitute misconduct, it shall advise the complainant and the legal practitioner in writing, detailing the reasons for its determination. I now turn to Government Amendment 119. As in the published bill, if the divisional committee determines that the act or omission which is the subject of the complaint constitutes misconduct, but that such conduct is not of a kind that needs to be referred to the legal practitioner's disciplinary tribunal, then the divisional committee can issue a direction to the legal practitioner under section 58. We've extended the number of sanctions that the committee may specify from taking account of the existing regime and submissions received. For example, a direction that the legal practitioner take such other action in the interests of the client as the committee may specify. Another is a direction can be made to the legal practitioner to pay a sum not exceeding €5,000 as compensation for any financial or other loss suffered by the client in consequence of any such inadequacy in the legal services provided or purported to be provided by the legal practitioner, provided that any such payment made is in compliance with the direction and is without prejudice to any legal right of the client. It is now open to the Complaints Committee to issue one or more of the measures contained in section 58(5)(a) to I. Where the legal practitioner complies with each such direction, the complaint shall be considered determined. It is also open to the committee, the Complaints Committee, under section 58(6)(a)(b) to caution, admonish or reprimand the legal practitioner in respect of the act or omission which has been the subject of the complaint, or direct the Law Society in the case of a solicitor to impose a specified restriction or condition on the practitioner of the precise measure it proposes to take. To impose a specified restriction or condition on the practicing certificate, of the legal practitioner concerned. In the case of a barrister, the Divisional Committee may direct the Chief Executive of the authority to impose a specified restriction or condition on the legal practitioner concerned in respect of his or her practice as a barrister. It's now provided that the legal practitioner must consent to the sanction in writing on the advices of the Office of the Attorney-General. A recent case involving the disciplining of a medical practitioner by the Medical Council held that the High Court would be the only body empowered to issue such a sanction. The Divisional Committee will therefore notify the legal practitioner of the precise measure it proposes to take. The notification will indicate that unless the legal practitioner concerned furnishes to the Divisional Committee his or her consent in writing to the imposition of the measure specified within 21 days of the notice, the Committee would apply to the legal practitioner's disciplinary tribunal for the holding of an inquiry into the complaint by the tribunal under this part. Where the Divisional Committee does not receive the written consent within 21 days, it shall apply to the legal practitioner's disciplinary tribunal for the holding of an inquiry by it into the complaint insofar as the Committee has not found that the complaints are unfounded or that the act or omission concerned does not constitute misconduct. Where the Divisional Committee considers the act or omission the subject of the complaint constitutes misconduct of a kind that is more appropriate for consideration by the legal practitioner's disciplinary tribunal, it has the discretion to make an application in respect to the matter to it for the holding of an inquiry, which is under section 60. In determining whether it would be more appropriate for the complaint to be considered by the tribunal, the Complaints Committee shall have regard to the extent of the misconduct which was disclosed, the course of the investigation of the complaint by the Complaints Committee. I appreciate, Chairman, that there's a very substantial amount of information contained in all of that, but I thought it was appropriate to go through the detail of what is proposed and the modalities or mechanics of how the new architecture will in practice operate. What we have done the time has been used well to flesh out in greater detail matters that were originally dealt with greater brevity in the original bill, and to address any issues of concern that have arising out of the submissions that we've received.
Okay. Anybody want to come in on any of that stuff? Deputy McGrath.
Amendment 115, is it? Speak on that?
Well, any of the amendments.
Oh, yeah, okay.
Discuss any of them.
Just first of all, can I just say that Minister and Chair, I welcome the Amendment 115 because I think that the whole issue of fraud and dishonesty is a huge issue in the broader society, and we've seen that in recent years where greed and dishonesty amongst a group of members within the legal profession, particularly during the Celtic Tiger, has led to a major damage. It's not just them. We've seen politics, we've seen business, we've seen the church, and we've also seen the legal profession. So it's important to say that we need amendments like this to ensure that there is public confidence in all these professions, and in this case, in the legal service, the legal profession. So I'd just like to say, recently, particularly, a lot of senior citizens have expressed concern to me about the whole issue. Do they have their trust and have their confidence following some of the cases that have arisen? So I think it's important that when we're dealing with Amendment 115 that we also say a broader message as well to the legal profession, that to ensure that those people that have let them down in the past, there was very seldom any really bad cases over the last 40 or 50 years, whereas recently there's been a string of cases. So I'm just making the point is that the legal profession themselves, and this amendment adds, they have to earn the respect and the trust of the population. And you don't get respect, as far as I'm concerned, you have to go out there and earn it. And I think sections A, B and C there, they deal with these particular issues. So what I'd say, Chairperson, is that action has got to be taken to deal with this issue, because we all suffer the consequences, and particularly the citizens of the state. We all want a legal profession that's very upfront, that's very professional, and that's very impartial. And gladly we have, the majority of them are doing an excellent job, but we have to ensure that when cases like this, like amendment number 115, these cases are dealt with in a professional, independent, and impartial way. Thank you.
Okay. Nobody else? Just one small point, Minister, that I might just bring to your attention. It's been said to me on numerous occasions that sometimes if a member of the public, and Deputy McGrath reminded me when he mentioned about maybe senior citizens who may have a complaint that against a member of the legal profession, be it a solicitor or a barrister, that sometimes when they approach other members of the legal profession to assist them in making the complaint, that they may actually be told, well, I don't want to get involved, or I don't want to take that case, I don't want to assist you. And very often then they may be left in a situation where they can't get any legal help and they have no legal background themselves. So it might be something worth considering, how can somebody get assistance if they find that the doors are all shut? And I don't think we can compel solicitors to take cases, but maybe there might be some avenue of approach where somebody can get assistance if they're totally frustrated and totally intimidated by the legal process. Just a point maybe that you might consider, maybe the various societies might consider as well, taking on board and maybe addressing at some stage, some way or other. So,
perhaps, Chairman, if I could just respond to two issues. Deputy Finian McGrath referred to professional, independent, and impartial system, or to adjudicate on allegations of misconduct, and emphasised the importance of such a system being in place in which there can be public confidence to deal with fraud or dishonesty. That's one of the matters that has been at the very heart of this bill since day one when it was published. It was to have a system in which there is public confidence, in which there can be no doubt of any description about the independence of the body dealing with adjudication matters, that the body isn't perceived to be an arm of the legal profession, whether it's fair or unfair to so describe it. It's seen to be independent, and it has a series of principles prescribed that it must apply in dealing with allegations of fraud or misconduct or other types of misbehaviour. And I think that the provisions, the totality of the bill, the philosophy behind the bill from day one, set out that objective, that these provisions, the time we've had has allowed us to tease out to a greater extent aspects of the architecture that I think are important. And I think that really feeds in also, Chairman, to answering your question. Once this body is established, an individual who believes that they have been a victim of misconduct by a solicitor or a barrister, or who alleges that, can, without requiring legal advice, make the complaint to the Legal Services Regulatory Authority. And the Legal Services Regulatory Authority will have an obligation to assess the matter in the manner detailed in the very extensive provisions we've been going through this afternoon. They shouldn't be intimidated. It isn't a question of them having to make a phone call to the Law Society or the Bar Council to make a complaint about someone who is a member of the Law Society or the Bar Council. It's about contacting a body that is independent of each of the bodies that are representative of the two arms of the legal profession. So I would hope that, that at a very early stage in its life, this body will be seen to be independent, will establish by the manner in which it deals with complaints received both its credibility and its fairness. And its fairness in dealing with complaints, fairness both to the complainant and the person who's complained against. The proper procedures will apply, and they will have everything from what are spurious complaints to very, very serious and valid complaints made to them. So we're trying to provide as detailed an architecture as is possible to enable that to happen.
Okay, thank you.
Just very briefly, Chair. Just first of all, I want to endorse what you said yourself there in relation to senior citizens and that kind of fear and intimidation. But I'm just looking at one complaint I have here in front of me, where this particular woman has been dealing with her case for 6 years in relation to a complaint.
Okay,
So
well,
I'm just
we
making
can't
the
get
point
into
that
that
there's a lot of people, no, I know I don't want to go into specific detail, but I just make the point, as well as being independent and impartial, we need to be efficient, and the new authority needs to be strongly efficient.
and obviously user-friendly as well to the
Yes.
citizens. Okay, so if everyone is satisfied, we'll proceed with these amendments. Amendment number 115, in the name of the Minister, that new section be there inserted. Is the amendment agreed?
Agreed.
Agreed. Amendment number 116, already discussed with 111. Minister to move.
I move.
The question is that a new section be there inserted. Is that agreed?
Agreed.
Agreed. Amendment 117, a new section already discussed with 115. In the name of the Minister to move.
I move.
That the new section be there inserted. Is that agreed?
Agreed.
Agreed. Amendment 118, in the name of the Minister, it's a new section already discussed with 115. The question is that the new section be there inserted. Is that agreed?
Agreed.
Amendment 119, in the name of the Minister, it's a new section already discussed with 115. Minister to move.
I move.
And the question is the new section be there inserted. Is that agreed?
Agreed.
Now we're on to amendment number 120, in the name of the Minister. It's a new section. Minister to move.
I so move, Chairman. This amendment is in respect of section 59, which provides that the authority report on the performance of its functions under this part. The report shall include information such as the number and type of complaints received by the authority during the reporting period, the general nature and outcome of the complaints, the number of complaints referred to the Complaints Committee, the outcome of those complaints. It's envisaged the report will be published at intervals no greater than 6 months.
Okay. Okay. The question is that this new section there inserted. Is that agreed?
Agreed.
Agreed. Amendment number 121, in the name of Deputy McGrath and Deputy McLaughlin. Acceptance of this amendment involved the deletion of section 52 of the bill. It's a new section. Deputy McGrath to move. Move. Okay. Anybody want to speak on that?
Deputy McGrath. Yeah, the issue here is the right to refer the matter to the High Court under, a point of law. It's trying to, I suppose, protect the rights, and it may become an issue anyway. So it's essentially what it is. Straightforward.
Minister.
Chairman, I'll be opposing this amendment, which was previously considered by me in the context of the Bar Council's March 2012 submission. I consider the bill's provisions, including as being amended in relation to the disciplinary tribunal and its relationship with the High Court, to be more than adequate for the purposes of the bill and its objectives. I will in any event be returning to this part of the bill for further amendment at report stage. There's some further amendments, I think, that will add additional flesh to the provisions that we're dealing with today.
Okay.
So just to be clear, Minister, what you're saying is you believe that you are addressing the concerns that amendment sought to address.
I'm saying that I don't believe there's a need for the amendment, but I...
Sorry, apologies.
Yeah,
it's trying to translate sometimes.
Through the chair now, please.
No, in the context of the current law and having regard to the content of the bill as now amended, I don't believe the amendment is necessary. But in the context of some of the issues we're dealing with here, there are a small number of additional amendments that we're considering and that weren't dealt with and finalised with the Office of the Attorney General prior to the commencement of committee stage. So we may be revisiting some aspects of this part, but at far less length than today at report stage.
Okay.
So, Minister, you're saying in relation to Amendment 121 that the amendments that you will bring forward will be connected with Amendment 121.
Well, they're of relevance to the overall issue,
Yeah.
but there won't, we don't believe there's a need for, I'm advised there isn't a need for the particular amendment that's proposed here. But if the deputies want to simply withdraw the amendment and bring it back into report stage in the context of the additional amendments we'll be bringing forward, I obviously have no difficulty of any description with that. But I would hope we'll be able to assure the deputies it isn't needed in this context.
Okay, how stands the amendment? Deputy McGrath?
You call it.
Well, Minister, these matters are negotiations, so I'll withdraw and hope to see at a later stage, okay? Or sorry, if that's agreed with Deputy McGrath.
Amendment withdrawn. 1, 2 are withdrawn. The question is that section 52 stands out of the bill. Is that agreed? Agreed. Okay. Section 53, Amendment 122 in the name of the Minister, 122 to 126 inclusive are related and they will be discussed together. Minister to move 122 and discuss the rest.
Yeah, I so move, Chairman. This amendment provides that the disciplinary tribunal will now be appointed by the President of the High Court rather than by the Government as a mark of the tribunal's independence. Government Amendment number 123 provides that one of the persons nominated shall be appointed as Chairman of the Disciplinary Tribunal. Another key change has been the removal of the role of the Government in nominating the lay persons to the Tribunal. The Minister must now ensure that the lay persons nominated to be members of the Disciplinary Tribunal are persons who are independent of the Government and the professional bodies and have knowledge and expertise as set out in the subsection, for example, in the provision of legal services, the interests of consumers, etc. The amendment also provides that the Disciplinary Tribunal can act in divisions of 3 and 5 members. At present, each division is to have a majority of lay members, one of whom will be the chairperson. But I may be returning to this at report stage to ensure the effective chairing of the Disciplinary Tribunal. So I just want to say that we're anxious to ensure that there is a lay involvement, but in the context of technical legal matters that could arise, we're reconsidering whether the chairman or the chairperson in this instance should in fact be one of the lawyer members, if I could put it that way, as opposed to the lay member. So we'll come back to that issue. Government amendments number 124, 125 are minor technical amendments which I'm told by Parliamentary Council are necessary. Government Amendment 126 provides for the appointment of the chairperson of the Disciplinary Tribunal. The person appointed as chairperson may either be a legal practitioner who's practiced for not less than 10 years, or where the person is not a legal practitioner, have knowledge and expertise in one of the areas set out in the subsection. The chairperson shall be appointed by the President of the High Court and the persons nominated by the Minister for membership of the Tribunal.
Okay. Deputy McLaughlin, you want to come in there?
No, it's okay.
It's okay. Right. Nobody else? Okay. I'll put the question then. Amendment 122 in the name of the Minister. That question is that the amendment be made. Is that agreed?
Agreed.
Agreed. Amendment 123 in the name of the Minister. Minister to move.
I so move.
That's already discussed. 122. Question is that the amendment be made. Is that agreed?
Agreed.
Amendment 124 in the name of the Minister. Already discussed. 122. Minister to move.
I move.
Question is the amendment be made. Is that agreed?
Agreed.
Amendment 125 in the name of the Minister. Already discussed. 122. Minister to move.
I move.
The question is the Minister amendment be made. Is that agreed?
Agreed.
And on the section, that section 53 is amended to stand part of the bill. Is that agreed?
Agreed.
Agreed. Section 54, Amendment 126 in the name of the Minister. This is a new section. It's already discussed in 122. And the Minister to move.
I move.
The question is that the new section be there instead. Is that agreed?
Agreed.
Agreed. Amendment 127, acceptance of this amendment involved the deletion of section 54 of the bill as a new section. Is the name of the Minister. Amendments 127 to 135 inclusive are related and will be discussed together. Minister to move and discuss.
Okay, I move, Chairman, amendment number 127. This provides an application for the holding of an inquiry by the Disciplinary Tribunal will be made by the authority. Amendments 128 and 129 are two technical amendments. The word legally in legally required and may legally require have been deleted. Amendment 130 provides the inquiry by the Disciplinary Tribunal will be conducted by way of oral hearing and will be in public. It also provides the Disciplinary Tribunal may direct that the hearing of the inquiry or any part thereof be held otherwise than in public where it is satisfied it's necessary to do so in the interests of justice. Amendment 131 substitutes authority for complainant. Amendment 132 provides the Tribunal may appoint an expert if it requires the advice or assistance of an expert in respect of any matter. 133 provides for a requirement to notify the parties of a determination and the reasons for that determination. 134 provides in this amendment that we are deleting, quote, the client and substituting complainant, as complainant is the more appropriate description in this instance. Government Amendment 135, we've inserted a provision that the legal practitioner of the Disciplinary Tribunal may direct that the legal practitioner pay a sum not exceeding €15,000 as restitution or part restitution to an aggrieved party. The section is based on Section 7, subsection 9 of the Solicitors Amendment Act 1960, and it will strengthen the sanctions available to the disciplinary tribunal. By way of clarification, I wish to confirm that I will be returning to the remaining provisions dealing with the disciplinary tribunal report stage when the remainder of amendments have been finalised by the Office of Parliamentary Counsel. That's what I referred to a short time ago, that there are some additional amendments that Parliamentary Counsel is still working on of relevance to this particular part of the bill.
Okay.
I just want to take the opportunity, Minister. There's been some concern that in terms of the membership of the disciplinary tribunal, not more than 16 members, and there's concerns that that may not be enough. Have you reflected on that?
I think we're still reflecting on that, Deputy. I don't have a closed mind on that. Just as we've increased the numbers in relation to the committee, we're giving further thought to that end of things as well.
Is that something that maybe could be looked at?
It's something that could be, if there's to be an increase in the numbers, we'll be dealing with that at report stage.
Okay. Okay. Anybody else? Okay, let's have put into questions. So, we're on Amendment 127. The question is that the new section be there in itself. Is that agreed? Agreed. Now, on the section itself, that section 54 stand part of the bill. I understand the decision should be in the negative. Is it agreed?
Agreed. No, sorry, no. That's
Not
one
agreed.
that's one we're replacing,
Yep.
Chairman.
Yep,
It's
okay.
deleted.
It's not agreed. So
Not agreed.
that falls. On section 55, the question is that section 55 stand part of the bill. Is that agreed?
That's agreed.
Agreed. On section 56, that section 56 stand part of the bill.
Agreed.
Agreed? Okay, agreed. Section 57, Amendment 128, the name of the Minister, already discussed at 127. The question is, amendment be made. Is that agreed?
Agreed.
Agreed. Amendment 129, the name of the Minister, already discussed at 127. Minister to move.
I move.
The question is, the amendment made. Is that agreed?
Agreed.
And the question is that Section 57 is amended, stand part of the bill. Agreed?
Agreed.
Agreed. Okay, Section 58, Amendment 130 in the name of the Minister, already discussed 127. Minister to move.
I move.
Question is, the amendment be made. Is that agreed?
Agreed.
Amendment 131 in the name of the Minister, already discussed at 127. Minister to move.
I move.
The question is that the amendment be made. Is that agreed?
Agreed.
Amendment 132 in the name of the Minister, already discussed at 127. Amendment Minister to move.
I move.
Question is the amendment be made. Is that agreed?
Agreed.
Amendment 133 in the name of the Minister, already discussed at 127. Minister to move.
I move.
Question is the amendment be made. Is that agreed?
Agreed.
Section 58 is amended, stand part of the bill. Agreed? Agreed. Okay, Section 59, Amendment 134 in the name of the Minister, already discussed at 127. Minister to move.
I move.
Question is the amendment be made. Is that agreed?
Agreed.
Amendment 135 in the name of the Minister, already discussed at 127. Minister to move.
I move.
Question is the amendment be made. Is that agreed?
Agreed.
Okay, the Section 59 is amended, stand part of the bill. Agreed?
Agreed.
On Section 60, the no amendments here. The question is that Section 60 stand part of the bill. Agreed?
Agreed.
On Section 61, again, no amendments here. The question is that Section 61 stand part of the bill. Agreed?
Agreed.
Section 62, again, no amendments here. The question is that Section 62 stand part of the bill. Is that agreed?
Agreed.
Section 63, Amendment 136 in the name of Deputy Collins. 136, 137, 141, 142, 143, 146, 147, 148 are related and will be discussed together. Deputy Collins to move.
I move, Chair. Thank you. Minister, these relate to the Irish Institute of Legal Executives, who are seeking to have, I suppose, a degree of formal recognition conferred upon their grouping. They're a significant player within the legal services, the provision of legal services. As you know, there's up to 600 members of the association, and it's in existence now for almost 30 years. And we, well, at least I intend, I'm sure others intend to return to, at report stage, seeking to have membership of the authority recognition for them at that level. But in terms of this part of the section, can you tell us what your views are in terms of providing or affording the Institute formal recognition that they can play a meaningful part in terms of the overall regulatory of the industry.
I'm going to say to the Deputy that's an issue for another day, not for this bill. This bill is dealing with solicitors and barristers and a whole range of regulatory issues in relation to the legal professions. It isn't my intention to extend this bill to apply to other groups, including the legal executives that you reference. That may be an issue for other legislation on another day, but there's a very substantial piece of legislation. It's in the public interest that we get on with enacting it. As I said, if not for other pressures, I would have hoped it would have been enacted earlier. And I don't intend to extend the ambit of the bill to legal executives.
Okay. Can I just, through the chair, can you tell us why, given that they're such a major player within the industry?
Well, the answer is that this is a bill dealing with solicitors and barristers.
Okay. Deputy McLaughlin.
Yeah, and now the issue's been raised. Notaries public, just again, it's just to put on the public record. We are getting representations. Why notaries public, why legal executives. It would be good just to clearly spell out why this legislation doesn't deal with them and why it's a matter.
Well, you see, Deputy, I could have given the same answer to Deputy Collins. There's a broad range of other individuals who are engaged in matters of some relevance, or either directly or indirectly, to legal services. Notary publics, legal cost accountants, legal executives. There are others. I could go on in the context of the manner in which people describe themselves and their engagements. And I'm not in any way being critical of their engagements. There's an increasing number now of legal executives doing particular type of work. But there's a very important discussion that needs to take place around all of this in a public context. Legal executives, I think part of what they are looking for is rights of audience, I think, in the district court, the circuit court. There's a whole range of issues about training, about legal expertise, about the limits to which different individuals should engage in the legal profession without being fully trained as lawyers. There's a range of, and these are public interest issues. It's not about preserving anyone's patch. As the deputies know, I'm an enthusiast for the provision of legal services through alternative business mechanisms to make the legal profession more competitive and to give lawyers other business options through which to provide legal advice, as well as the community, general community and general public, an opportunity to access legal advice. But in the context of this bill, we have a very substantial agenda. I appreciate the role played by legal executives and others, but it's for another day, and it requires a far greater and a different discussion, indeed, than incorporating it at this stage within this bill or providing for their regulation through the Legal Services Regulatory Authority. So what I believe we need to do in the public interest is get on and enact this bill, establish the Legal Service Regulatory Authority, have the new measures in place, and then on some other occasion at a later date, other bodies who are engaged in aspects of law and for whom there may be a need, also in the public interest, I would say, for some form of regulation, because one of the issues is to ensure that people also don't claim to have expertise that they don't have, and that as a consequence members of the public may not always be well served. So there are issues to be considered and addressed which transcend this bill. This bill is a very comprehensive, very complex and piece of legislation which is introducing very, very substantial public interest reforms, and it isn't practical, nor do I believe at this moment in time appropriate that we extend it.
Okay, can I ask through the chair, please, just Minister, can you clarify, just by way of information for us, you've indicated that you intend to bring forward legislation in relation to legal executives. Is it entire?
Didn't, Deputy. I said it's.
Sorry.
I said that requires a far broader debate. I didn't say I intend to bring forward legislation. I said if there were to be legislation before any government makes any decision or any minister makes any decision, there's a need for a wider debate as to what are the roles of legal executives? What should be the outer limits of those roles? What education system should be put in place to ensure consistency of knowledge and education? To what extent legal executives have essentially grown around the legal profession over the years, and there would be, for example, within law firms, a number of individuals very competent at the work they do, style legal executives who may exclusively, for example, do conveyancing. And they may have no expertise outside that, but they do that and very well and very efficiently. And then you may have another individual who's a legal executive who knows something about law in the personal injuries area, but outside that has no knowledge or expertise, but effectively acts as a legal executive in that area, effectively working under the supervision of a solicitor. So it isn't simply a question of one deciding we should have legislation and then trying to search out what the legislation should prescribe. I think there are public policy issues, first of all, to be addressed as to what are the diversity of roles, for example, legal executives currently play. Is it in the public interest or is it not that they be regulated in a particular way? If they were to be regulated, what should be the nature of that regulation? In what way could that regulation ensure that it worked appropriately and, to use that awful word I used earlier, seamlessly, in a sense, in its interaction with the legal professions as they operate? How do you ensure that the public, if they approach someone who's a legal executive rather than a barrister or a solicitor, has knowledge of the level of expertise of the individual that they're dealing with? These are issues, and I can tell you as a practicing lawyer for many years, these are issues around which I'd have some concerns. That there are some very good people who are working in confined areas as legal executives, and there are some others who are legal executives who may or may not have the qualifications to work in the areas they're working in. So that there's a whole range of issues that are public interest issues that would need to be considered. So I'm not making a commitment to legislate. I'm saying before you even get to that point, there are a whole range of policy issues that need to be considered in the context of the public interest. And when some reasonable decisions are made on those, there is then the issue of is there a need or is there not a need for legislation. But it's not, the legislation isn't going to be contained in this particular bill because of the need for us to bring to completion the legislative process in an area that is already as complex as it need be and which is providing for very substantial reform. The legal profession, and it's worth pointing this out, as we have it in this state and as it's developed over the years, it developed to 1922. There's a very, if anyone ever wants to read the history of how the legal profession developed in England and Ireland as it evolved through the 17th, 18th and 19th century, it is in the form it's in more by accident than design, partially, well, for a whole range of reasons which I won't go into. And it hasn't evolved and changed since 1922, whilst it has evolved in other countries. And this legislation is providing the architecture for the possibility of evolution and change in the public interest and in the interest of those who are qualified lawyers who have skills that can be utilised to generate income for them and skills that they can use in the interests of the public, and to provide for how that can be done in ways that both reflect the way it's presently done and in other ways, whilst we completely update our provisions with regard to regulatory disciplinary matters and deal with a broad range of legal cost issues in a manner that gives statutory expression to very important principles, some of which have been there for some time but which haven't formed part of our statute law. I think we've enough on we're dealing with in this bill without trying to extend its scope to an entirely different group of individuals.
Anybody else? Okay, I'll put the question. How stands the amendment, Deputy Collins?
I press it, please.
The amendment. We're on section 63, amendment 136, in the name of Collins. And the question is that the amendment be made. Those in favour say Tá. Those against say Neil.
Neil.
I think the question is lost. Question lost. Now, on the section 63, the questions of section 63 stand part of the bill. Is that agreed?
Agreed.
Agreed. Section 64, no amendments here. The question is that section 64 stand part of the bill. Agreed?
Agreed.
Section 65, again, no amendments. The question is that section 65 stand part of the bill. Agreed?
Agreed.
Section 66, already discussed with 136 in the name of Deputy Collins. How stand that amendment?
137.
137, sorry.
Yeah, I'll move it, please.
Amendment moved. On amendment number 137, the question is that the amendment be made. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I think the amendment is lost. Amendment lost. Section 66, the question is that section 66 stand part of the bill. Agreed?
Agreed.
Section 67, no amendments here. That section 67 stand part of the bill. Agreed?
Agreed.
Agreed. Section 68, again, no amendments here. The question is that section 68 stand part of the bill. Is that agreed?
Agreed.
Section 69, Amendment 138, in the name of the Minister. Acceptance of this amendment involves the deletion of section 69 of the bill. If 138 is agreed, 141 to 149 inclusive cannot be moved. So we're dealing with 138 now. It was 150, 151 and 154. They're all related. 144, 45 and 49 are alternatives to 138. 138, 144, 145, 149, 150, 151 and 152 will be discussed together. Minister to move 138.
I so move, Chairman. I should say at the outset of these amendments dealing with Part 6 of the bill that I must oppose, just for the time being, opposition amendments number 144 and 145, which relate to a matter that the Law Society has very recently put to me in written correspondence. I want to assure the Deputy that I will indeed consider a reference to a register rather than a role of practising solicitors. And I'll bring such an amendment to report stage if and when I am satisfied it would represent a fairer calculation of the levy in relation to solicitors. However, I'm afraid I cannot support the Deputy's attempt to protect the Bar Council from suit in the event that it refuses to pay a due levy, and so I must oppose opposition amendment number 149. Turning now to the remaining government amendments number 138, 150, 151 and 152, I should set out that Part 6 of the bill as published consists of two sections, namely Section 69 and Section 70. I propose the deletion of both sections and the substitution with 4 new sections to provide in detail for the fair and equitable calculation and payment of a levy on legal practitioners in order to fund the operational expenses of both Legal Services Regulatory Authority and Legal Practitioners Disciplinary Tribunal. The original provision sought to achieve the same goal. However, the need for certain amendments came to light in the intervening period since publication in 2011. The new configuration of this part reflects certain of the representations made by the Law Society and the Bar Council in particular, and I believe that their concerns that the levy terms should be balanced and fair will be allayed. I'll now take the committee through the proposed new sections in sequence. The first is new section 69. This reflects a broadening of the traditional model of the provision of legal services by barristers and comprehends those barristers who choose to practice outside the law library. While barristers may continue to operate from the law library as sole traders, other persons who have been called to the bar should therefore be permitted to offer their services outside that structure, including as employees. That is why Section 69 now makes a distinction that there will be, for the purpose of calculating the levy, 3 categories of practising legal practitioners, namely solicitors, barristers who are members of the law library, barristers who are not members of the law library. Subsection 1 provides that the Law Society will be responsible for paying to the authority the levy amount on behalf of solicitors. The Bar Council will be responsible for paying the levy on behalf of its members. Those barristers who are not members of the law library will be individually responsible for paying the levy directly to the authority. I will be refining the practising status of these categories of legal practitioners for report stage. Subsections 2 to 3 are essentially carried over from the published bill and provide that the authority shall determine its and the tribunal's operating costs and administrative expenses at the end of each financial year. These costs are standard remuneration and accommodation costs, found in many instances throughout the statute book. Subsection 4 provides that these expenses shall be divided equitably between the three categories of legal practitioners. It's important to note here that the levy calculations are based on the proportions of the expenses that were incurred by the authority in the consideration and investigation of complaints in relation to three categories of legal practitioner, and not an accrued calculation based on the proportion of complaints received in relation to each. This is an important distinction that reflects the fact that some investigations will be more complex and lengthy than others, and it would be unfair to burden one category of legal practitioner with costs associated with a different category of practitioner. Subsection 5 sets out that the authority, in consultation with the tribunal, will every year calculate how the expenses of the tribunal will be apportioned between the Law Society, the Bar Council, non-law, library, member, barristers. Subsection 6 simply provides that the sum total of the levy payable will constitute the expenses of both disciplinary bodies, that's the authority and the tribunal. Subsection 7 is a detailed and somewhat technically complex provision to provide for the method of calculation in relation to the levy to be imposed on legal practitioners. This has been worked out in conjunction with Parliamentary Council. It takes cognizance of written representations made to me by various interested parties that the levy calculation the bill has published was in need of some finessing. The subsection is subdivided into three paragraphs as follows. Paragraph A, dealing with the authority's expenses incurred in fulfilling its remit as a complaints handling disciplinary body. Paragraph B deals with the authority's expenses incurred in fulfilling its other non-complaints related functions as set out in section 9, which deal with the authority's functions. Paragraph C dealing with the tribunal's expenses. The calculation ratio is that 10% of the expenses incurred by the authority and the tribunal and their disciplinary related functions will be apportioned to the Law Society, 10% to all practising barristers, whether or not members of the Law Library. The remaining 80% will be apportioned in proportion to the expenses incurred in the consideration and investigation of complaints in respect to the three categories of legal practitioner. The expenses incurred by the authority in fulfilling its non-complaints related functions will be apportioned pro rata between the three groups. Subsections 9 and 10 provide that a levy assessment notice shall be sent at the end of each financial year to the relevant professional bodies or individuals, as the case may be, specifying the total due to be paid and the detailed breakdown of the final tally. The initial set-up costs for the new bodies will be paid for by the Exchequer on a recoupable basis via the levy. Subsection 11 sets out that the levy is to be paid to the Exchequer. The remaining subsections 12 and 13 are standard provisions to clarify terminology and references in this part of the bill. Section 70 is a common sense provision to ensure the authority has sufficient power to compel payment of the levy by the relevant persons within a reasonable 3-month time frame. Failure to pay the levy may result in an individual legal practitioner being prevented from providing legal services, or may result in the authority suing the Law Society or Bar Council till payment is made. Section 71 provides for an exemption from payment of the levy for legal practitioners who are in the full-time service of the state. I'll return to this particular provision again at report stage, as it is intrinsically linked to the definitions of practising solicitor and practising barrister, which, as I had already flagged during the July 2013 committee stage hearing, I will be returning to. This is due to the fact that those definitions had not been settled to the satisfaction of Parliamentary Council. Section 72 is a standard regulation making provision that is already to be found in the original bill as published.
Okay, Deputy McLaughlin.
You appreciate exactly what the issues are here, Minister, and you've received representations from the various bodies, Law Society, Bar Council particularly, that both organisations, representative organisations, will want to ensure as fair as possible based on the level of complaints reflecting their respective legal practitioners that they represent. So the first one, I am disappointed that the register of practising solicitors, I think that's an absolutely valid point, that the register of solicitors is much larger than it should reflect those who are practising solicitors. And I note that you've indicated you may well address that at report stage. that would be, in my view, very important that that is addressed. I think that is a very fair point. The Bar Council, like similarly to earlier exchanges, I think it's important because, in fairness to the Law Society and Bar Council, they're paying. And they have no problem with that. They've never indicated that in representations. They accept that they should pay for this new authority. But all they're saying is that there's a fair distribution. And I would just ask that in relation to what you've indicated, that you add this to the agenda for your meeting with the Law Society to to deal with their concern around that is practicing solicitors. And similarly in terms of the Bar Council, that it is frustrating because we have tried to put in amendments here today that are ruled out of order because they're a potential charge to the Exchequer. But this isn't. It's not. So we're trying to engage with amendments to try and get a discussion on it, and it's not permitted. So that's fair enough. That's the standing orders. We have to accept that. But I think it is reasonable that the bodies who are paying for this, that are making it happen, would be consulted in relation to making it as fair as possible. And that's the purpose of the amendments that were ruled out of order and the amendments that are still here on the list.
Okay. Could I just respond to the Deputy by saying there has been extensive engagement with both the professional bodies, as well as obviously we've had regard to any submissions otherwise received. I would agree that any levy should, in the context of solicitors, apply to practicing solicitors. You can't levy the Law Society for retired solicitors or struck-off solicitors, or indeed deceased solicitors. And no one is suggesting that we should do so. So insofar as or even for one or two solicitors who are in Nick, and who are no longer practicing, so yes, we will be appropriately engaged. But there has been also, I want to assure deputies that there has been extensive engagement of a practical nature to ensure the workings of this bill are fair, fair to those engaged in the professions, fair to the general public, and that the public interest is protected. And they're the very important matters of concern. It's also fair to taxpayers, so that the general public who are paying their taxes don't have to fund the system, and it's appropriately funded. And there are nuances within the different within the professions, between practicing solicitors, between barristers who are members of the Bar Library, barristers who are not members of the Bar Library but who are practicing, as to how fees should be levied. And there would have to be fairness in the context of that as well, so that individuals, for example, aren't required to pay for something that they don't benefit from, they're not engaged with. So there are issues in this context that do require some further consideration. There was some very recent submissions made to us as we led into today's meeting, to which I've already given very detailed consideration, and we'll come back to any outstanding matters that need to be addressed at report stage.
Okay. Anybody else? Okay. Sorry. Oh, sorry, Deputy McNamara. I'm sorry. I apologise.
Thank you, Chairman. I suppose at the outset, I should state that I am a barrister, as I stated when it was being discussed at second stage, although I'm on leave from the Law Library for the duration of my of this stall. I would greatly welcome the Minister's amendment, but I just want to express a reservation in respect of one part of it. I welcome the distinction and differentiation between barristers who are members of the Law Library and barristers who are not. The Minister discussed this, the fact that there are practicing barristers who are not members of the Law Library. It's not maybe as revolutionary as some will no doubt claim it is. I mean, the Constitution of the Bar of Ireland says that the Council shall maintain a register of all practicing barristers, and that register shall be maintained under the control of the Council by the Director of the Council, and shall be in two parts, consisting of respectively all members of the Law Library and all other persons who submit to the jurisdiction of the Council in accordance with regulations in force from time to time. Notwithstanding that, and to use a legal term, the Bar Council has failed, refused or neglected to have a register of practicing barristers who are not members of the law library. Now, there's been a lot of discussion of the rule of law in the context of this bill and potential damage to the rule of law. One of the most basic tenets of the rule of law is that every organisation, even ping pong clubs, adhere to their own rules. But notwithstanding the fact that the Bar Council doesn't maintain a register of practising barristers who are not members of the law library, I'm aware of a number of barristers who practice, particularly, it has to be said, in the southwestern and the southern circuits, who practice as barristers, notwithstanding not being members of the not being registered. But there's no mechanism by which they can be registered. Now, the danger with that is they're not doing anything unlawful in any way, because there's no legal requirement for a barrister to have a practising cert issued by anybody. Even the practice of issuing practising certs is relatively new. But they're not susceptible to any disciplinary mechanism or regulation by anybody through no fault of their own. They could, of course, be subscribing members of the law library, and it has to be said that there are two categories of subscribing members of the law library at present: those who are based in Dublin or quite near Dublin, and those who are considered, I think, as country members or further from Dublin, who would obviously have less use for the law library. But, you know, there are a number of barristers who, for whatever reason, don't see the law library as being of any benefit to them, so they don't subscribe to it. Now, the law library is undoubtedly of benefit to very many barristers, but that's, I think, a choice, because there's a cost involved in subscribing to the law library, and that cost, like all costs involved in the provision of any service, is eventually passed on to consumers. And one of the purposes of this bill is, I think, to drive down legal costs and to at least bring a certain degree of transparency to them. But notwithstanding all of that, my concern would be that there are three categories. You have the law library pays a share of, or sorry, not the law library, the Bar Council pays a share of it, the Law Society pays a share, and then barristers who are not members of the law library. But barristers who are not members of the law library will still have to be on a roll of barristers somewhere. And that at the moment is not dealt with in the amendments, because it's part 8 of the bill, but it's section 76, which provides that the Bar Council shall maintain a role. Now, there's nothing at all wrong with that, and there's nothing necessarily which conflicts between that and what the Minister is introducing. But my concern would be that the Bar Council might seek to introduce part of the cost, the regulatory cost for barristers who are not members of the law library, that they might have to pay some of that as part of their practising fee, or that they could even, as a condition of the practising fee, have to pay some of the cost of maintaining the law library, which would defeat the purpose of this. So I think it's something that will have to be teased out in subsequent amendments. I would flag that, but on the other hand, one of the great benefits of the law library is undoubtedly a fair degree of access to the profession of being a barrister, and that everybody, in theory at least, gets an equal crack at the whip. Practice might be very different, but in theory at least everybody gets the same crack at the whip. But there has to be a system, as there is with solicitors, there has to be a system by which people apprentice or do a pupillage, or deviling as it was referred to until quite recently. And clearly barristers won't be able to develop their professional, their profession, and develop into barristers as in-house barristers with Bank of Ireland or even in-house counsel here in the Oireachtas. So just as, I mean, the bar in Britain, you know, everybody, there are sole practitioners, they're on the roll of barristers held by the Bar Council of Britain, but all barristers who become, you have to do a pupillage, and that's always done in chambers. So I suppose my concern is the conditions which the Bar Council, I'd like to see the bill at subsequent amendments address the conditions that the Bar Council will be able to lay down to issue a practising cert, because it will now become unlawful, for the first time in Irish law, it will become unlawful for a barrister to practice without a practising cert. Okay. And also the cost that the Bar Council can charge for that practising cert. What will the Bar Council be able to levy? Will they be, for those barristers who are in Cork or the Southwest or wherever, who are now practising without being members of the law library, will they suddenly have to end up paying for the law library through the back door? Because that would defeat the purpose of the bill. But on the other hand, I think it's important, and it's very important in my view. I mean, this is dealt with by Section 51 of the UK Legal Services Bill, which provides that the payment of any fee which is a prerequisite to obtaining a practicing cert shall have to be approved by the regulatory body. And that sets out that Section 51 of the UK Bill sets out permitted purposes that the fee can be diverted towards and purposes that the fee can't be diverted towards. And I mean, the fee can be diverted towards promotion of the rule of law, human rights, interaction on behalf of the body, but also education. And I mean, it's that it's ensuring that even in-house barristers who work for a bank or whatever, or who decide to be sole practitioners or who decide to set up a chambers, as barristers I've no doubt will do across Ireland. Some will frown on it, some will say the law library is a bastion which must not change, we shall not move, we shall not change, and that everything will be fossilised as it was in 1922. But there are others who will set up chambers. But what's important is that there is still, that all barristers contribute to the development of the profession and ensuring that there's equality of access to the profession. And that barristers can, once they enter the profession, once they come out of King's Inns, that you won't have 120 or 150 barristers coming out of King's Inns and only 30 getting a pupillage somewhere. So, you know, which will, once you keep the numbers very small, well then obviously there are anti-competitive issues. So I suppose it's ensuring that somehow once the practicing fee, that there's a degree of control over the practicing fee, the purposes towards which that practicing fee can be diverted, and ensuring that one of those purposes is maintaining access to the bar and maintaining a training mechanism.
Okay,
Thanks.
Minister.
To that. I very particularly made in referencing the levy to be paid by solicitors, barristers, and then barristers who are members of the library and those who are not. Made reference to ensuring that the manner in which this is dealt with is fair and appropriate based on a number of issues, a number of matters. The deputy is right. He's raised an issue that's a little bit previous. We'll come to it in Part 8 of the bill when we get to Part 8 of the bill. But I don't want to go into things in any great detail. But consideration has been given to some of the issues he's raised. The levy that will arise in respect of members of the bar who are not members of the bar library but who are practicing barristers, I'll be bringing forward an amendment to deal with that matter on the basis of that levy being paid to the Legal Services Regulatory Authority, and the Legal Services Regulatory Authority maintaining the role of barristers who are not members of the bar library. So there will be effectively a role of barristers who are not members of the bar library that, as I understand, doesn't exist at the moment. The mechanics of calculating the levy, the deputy has raised an interesting issue with regard to members of the bar who don't utilise the facilities of the bar library. And if they're practicing barristers, presumably they have other expenditure themselves by way of office outgoings and accessing through their own expenditure legal journals or court judgments delivered, etc. So we may need to give a little bit of additional thought to that aspect of things, but some of the issues the Deputy has raised we will be coming to in Part 8 of the bill when we circulate the next list of amendments, and it will give us an opportunity to further tease those aspects of matters out, and as I've said earlier, we will then have the opportunity at report stage to address issues that don't prove possible to address between now and the next day of committee.
Okay, Deputy McLaughlin, you want to come in on this?
Yeah, there was also a concern, and it's still here in your new proposed section 69, subsection 11. That's been interpreted as potentially a dividend being returned to government, and there's concern that has that been interpreted rightly or wrongly? Maybe just tease that one through with us, you know.
I'm sure I would get a round of applause from my colleague Minister for Howland if we were going to return a dividend. That isn't the way this works. Clearly there'll be a start-up year, and the state is going to have to deal with the cost of the start-up year. And it's envisaged then that the sums payable by the professions will be retrospective to a degree. We have to look at, I want to have another look at the modalities of the start-up year and funding and how that's going to work, because I think there's a transitional arrangement that we do need. But no, what is sought here is that there will be there'll be expenditure incurred. It'll be allocated in the manner prescribed in the bill. That monies that go back to the state will be monies that go to the state to reimburse the state for expenditures had to incur in relation to the functioning of the Legal Services Regulatory Authority, and both on the disciplinary end and the other end of it. But there are issues of a transitional nature that we will be coming back to, Deputy.
Mr. Chairman, just finally, so just to clarify, Minister, what you're saying is that you're going to engage with the Law Society or your department with the Bar Council in relation to just listening to any concerns they have about this most recent amendment from yourself, that it would be a fair distribution, and then that issue of registered, practicing solicitors rather than just the register. You can.
We are engaged with great regularity, but I'm anticipating further engagement in the coming days.
I'll take this a yes.
Okay then, are we all happy with that so far? Nobody else wants to come in. So let's start putting the questions. So then, we're talking about section 69, where amendment 138 in the name of the Minister, and the question is that the new section be there in itself. Is that agreed?
Great.
Amendment 139 is out of order. Amendment 140 is out of order. Amendment 141 cannot be moved. 142 cannot be moved. 143 cannot be moved. 144 cannot be moved. 145 cannot be moved. 146 cannot be moved. 147 cannot be moved. 148 cannot be moved. And 149 cannot be moved. On the section 69, I know the section is opposed here by Deputy McGrath and Deputy McLaughlin. Do you want to speak to the section?
No, comments are made.
So I'll put the question then that section 69 stand part of the bill, and it has to be in the negative. Neil. Okay. The question is lost. Next section is section 70, Amendment 150 in the name of the Minister. Acceptance of this amendment involves the deletion of section 70 of the bill as a new section. It's already discussed with 138, and the Minister, the question is that the new section be there inserted. Is that agreed?
Agreed.
Agreed. And the question on the section, that section 70 is stand part of the bill. This decision, I'm told, should be in the negative.
That's Neil.
Neil. So the section is lost. Section 71 is Amendment 151 in the Minister. It's a new section. I discussed with 138. The question is that the new section be there inserted. Is that agreed?
Agreed.
Section 152 in the name of the Minister. It's a new section. I discussed 138. The question is the new section be there inserted. Is that agreed?
Agreed.
We've run out of amendments, so what are we going to do? Adjourning?
We're adjourned.
We're going to adjourn until future date, possibly next week. We may be dealing with another bill, maybe the fines bill or something else. So I want to thank everybody for your cooperation today.
Could I just say, Chairman, that I would hope, my hopes aren't always fulfilled, but I would hope within the next 10 to 14 days to have the final tranche of amendments for distribution. And I'm loath first to fix a date for the matter until I know for sure when they'll be available to me, so that deputies do have time to consider them. Obviously, we've covered a major portion of the bill now, so the amendments are a good deal less extensive but there are still a number of important ones that have been worked on. So perhaps Chairman will communicate with the clerk of the committee when I have greater visibility on the date when we should be able to distribute and publish them, and in that context we'll fix the next date for the recommencement of this committee on the Legal Services Bill.
Thank you, Minister. Just for information of members, we've penciled here 10 a.m. on the 22nd, the fines payment and recovery bill 2013. The following day at 10:30 we have an informal meeting with the Northern Ireland Justice Committee re human trafficking, and then we have estimates on the 29th at 9:30, Justice and Defence estimates, and at 4 p.m. Meeting in relation to community courts.
Is the fines amendment bill scheduled for?
The fines bill is for 10 a.m. to 1 p.m. on the 22nd.
That's what day of the
That's
week?
this time next week, Wednesday.
Is that Wednesday?
It's
Wednesday,
Wednesday at 10, yeah.
10 a.m.
Meeting adjourned.
Meeting adjourned today.